President, please be seated. The court is now back in session. Before we adjourned for lunch, it was about the opportunity given to lead co-lawyers for the civil parties to put some questions. The chamber will give the floor to the lead co-lawyers very soon, but before that we would like to rule on the case of Mr. Kyu Sampon regarding his waiver. As the chamber already notified the parties to the proceedings, the chamber would like to fully respect the rights of the accused, and the chamber notes that we have examined the reports by the medical doctors, and that this afternoon we also need to conduct a hearing concerning the severance. The chamber will issue the decision in due course. However, having notified the parties concerning this, we did not receive the waiver by the accused as yet, but recently we obtained such waiver from the accused due to his health concerns. He said he was fatigued and that his concentration was not good. And the chamber notes that this examination is of technical nature and it is up to his counsels to decide along with Mr. Kyu Sampon on this, and we therefore respect his full right. The chamber would like to ask that security officers and personnel are now bringing Mr. Kyu Sampon back to his detention facility, and the proceedings here before us continue. Lead co-lawyers for the civil parties, you may now proceed. Counsel Bik Ong. Thank you, Mr. President, and your honors. Civil party lead co-lawyers would like to hand over to Counsel Hong Kum Soon to put some questions, followed by Counsel Simonov. The President, thank you. Counsel Kum Soon, you may now proceed. Counsel Hong Kum Soon. Thank you, Mr. President, and your honors. And good afternoon, Dr. John Campbell and Dr. Sina Fazel. I am Hong Kum Soon. I am here representing civil parties, and I have very few questions to put to you concerning your report. I have listened very carefully to the questions put by Judge Cartwright to you concerning your report E256/4, and I have noted in your final conclusion concerning the health condition of Mr. Sri, and that you concluded that he is fit. My question to you is, to your opinion or observation, what is the difference between having Mr. Nuon Chea being present in the courtroom and his being present in the holding cell, and what would be the consequences otherwise?
I'm not sure we can answer that question. From a medical perspective, we've made our views clear in our report, and that we can only reiterate the fact that we don't see any reason why Nuon Chea cannot be present in the holding cell. But further than that, I can't comment.
Are you questioning whether he should be in the court here, present, or in the holding cell? He is much more comfortable lying flat, and that would be difficult in the court here.
Counsel, I may wish to ask this follow-up question. If Mr. Nuon Chea were to be brought into the courtroom, would that help him physically, for example, by allowing him to be more active when he has to move from downstairs upstairs, for example?
I can't see that it would improve the situation.
Counsel, thank you. You already testified before this chamber and also reiterated in your report that Mr. Nuon Chea, when remains in detention facility, tends to lie back, and that you observe because he remains motionless like that, he lacks some activity to keep him active. Do you believe that by bringing him into the courtroom helps him do some exercise? And or is it to understand that having him in the holding cell does not make any difference because he doesn't do any exercise either ways?
No, I cannot see that bringing him into the courtroom here would increase his exercise, his activity really at all. It needs a program when the court is not in session.
Counsel, thank you. Can you please also tell the chamber what would be best for Mr. Nuon Chea when sitting up or lying down? I mean, between the two, rather.
At this stage, he seems much more comfortable lying down, and I think that's what he'd prefer. It's difficult to get him sitting up for any length of time.
Counsel, thank you. Have you provided any advice to his health, for example, by asking him to do more exercises?
Sorry, I'm not clear about the question.
Council Hong Kam Soon, I was asking you that indeed when he lies down a lot, then his health is not good. Have you done something to ask him, for example, to be more active physically so that his health improves?
No, I've not been seeing him in terms of trying to improve his health. What I'm suggesting is that he needs a program of physical exercise to try and increase his muscle strength and his stability. And that would need to be a planned program, taking into consideration his other health problems. It's not something that can be dealt with in a very short time. It needs to be sustained over a period.
Council, thank you. You have examined his health condition, and with that, I would like to ask a question whether Nuon Chea has ever told you that he would like someone to give him a massage?
No, I've not discussed massage with him.
Council, thank you. In your conclusion, you indicated that you have no recommendation for a change, and I refer to your report in paragraph 49, which you state in that you said, therefore we would not recommend any changes to court proceedings in relation to the timing of sessions, which we understand are no longer than 90 minutes. With that, do we understand that Mr. Nuon Chea can remain in the court proceedings for 90 minutes?
Well, that was our feeling after having examined him on a number of occasions for periods for longer than 90 minutes.
Comment? Council, thank you. At paragraph 44, you also write that he said, it means referring to Nuon Chea, he would be willing to be physically present in court and speak, but thinks that his health would not allow him to do so. And he said that he would be willing to give evidence on video link and would prefer to do so from the detention center as he becomes dizzy if moved to the court. My question to you regarding this question, what would be the remedy in place to help him to deal with the situation when he feels dizzy?
Well, we referred previously to the fact that we would recommend that he be given 15 to 30 minutes to settle after he's moved to the holding cell. That would be one remedy. The second remedy is that if he complains of pain in his back or his waist, that he be offered oral paracetamol. And the third piece of good practice would be that when he is moved, it's done as carefully as possible, and I think that that's already the case, that people move him very carefully, and without too much disruption to his back.
Council, thank you very much for responding to all the questions. I have no further questions, yet my colleague would like to have a few more questions, please. Thank you.
Bonjour, Monsieur le Président.
Good afternoon, Mr. President. Good afternoon, Your Honours. Good morning. Good afternoon, rather, to all parties, and good afternoon to you, experts. I have a very few brief questions that cover an array of subjects. My first question would relate to Mr. Nunchia's cataracts. You state that he has bilateral cataracts and that operating on these cataracts would be rather straightforward. We all agree that vision is required in order to read documents and to enhance one's participation. And it would also be preferable to have some documents read to him. Is there a reason why such an operation has not been administered on Mr. Nunchia?
It was evidently considered earlier, but not gone ahead with. But we could not find the reasoning behind that. If he did have cataracts removed, it would take a significant time before he was ready for reading. And the more practical solution would be to have the documents in larger print, to have them on tape, or to have them read to him.
Thank you. Can I gather from your response, therefore, that you do not favor an operation on his cataracts?
I wouldn't consider myself qualified to comment on that. That would need to be a decision by an ophthalmologist, someone who examined the eyes more fully than I was able to with the equipment I had available.
Thank you very much. My second question concerns your joint authorship of this expert report. You have arrived at common conclusions, and you agree entirely on the conclusions. Were there any points of disagreement between you two gentlemen?
There were no points of disagreement.
That's right, there were no points of disagreement.
Thank you very much for that very clear answer. And a third question on an entirely different subject. You heard my learned friend talk about Mr. Nunchia's possible presence in these proceedings, and not strictly from the holding cell. And I'm sure you understand that his presence will have great significance, notably for the civil parties and obviously for the public at large. So that we are all absolutely clear on the matter, can you please summarize before this chamber, before everyone present, the reasons that would prevent Mr. Nunchia's presence in these proceedings? In other words, reasons why you would recommend he participate in the proceedings from his holding cell, in order for the reasons to be spelt out and be most clear and explicit for those who are following your testimony.
I think if he had to sit in the court, he would find that more uncomfortable and more difficult to sustain over the period of the court sitting. If he were able to lie in court, then that might be a possibility.
est-ce qu'on pourrait redonner?
Could we please hand the microphone over to Dr. Fazal so that he may provide his answer?
There's one other consideration, which is that the holding cell does provide the opportunity for immediate medical support, in the sense that, for instance, if he was asking for some pain relief, he could be provided it. So that's one other consideration, is just the availability of medical support in the holding cell.
Yeah, it's really.
Je vous remercie.
Thank you. As far as I'm concerned, I have no further questions. Thank you very much, Mr. President.
The President, thank you, councils. We would like now to hand over to councils for Mr. Noon Chie, because the chamber noted at the beginning that at the end the chamber would like to hand the floor over to councils for the accused to have a few final comments, observations, if they would like to do so. Council Sonarun. Good afternoon, Mr. President, again, and good afternoon, Your Honors, and good afternoon to you, both professors. I have no further questions on this, but we would like to have our final observation on behalf of Mr. Noon Chie. The President, thank you, Council, but that moment has not yet arrived. Council, with that, I have no further questions, Mr. President. The President, thank you very much. The session on the examination of the report filed by medical experts regarding the health and fitness of Mr. Noon Chie to stand trial now almost comes to an end. The chamber also notes the presence of the experts and that you are now excused. We believe that your report and testimony would be very helpful for the chamber to consider the health and fitness of Mr. Noon Chie. And on behalf of the trial chamber, we would like to express our profound thanks to both professors, Professor Campbell and Fazal, for doing your professional best and being very patient in responding to all the questions put to you, and we appreciate your very valuable time. We know that you have traveled all the way from your countries to conduct the assessment as ordered by the chamber. Finally, the chamber would like to wish you all the very best and safe trip back home. Court officer is now instructed to assist both professors and make sure that they are returned home safe and sound. Thank you.
The President, next, I wish to hand over the floor to the defense team for Mr. Nguyen Chie to make your final closing statement on the first topic of the hearing today. You may proceed. Counsel Sonarun. Good afternoon, Mr. President. Good afternoon, Your Honors. By way of concluding this topic, in my capacity as the defense lawyer for Mr. Nguyen Chie, first, based on the report of the expert dated the 20th of March 2013, two, pursuant to the hearing, the oral hearing of the two experts seen this morning, it is clear that my client is still suffering from many ailments, including hypertension, the inflamed respiratory system, back pain, as well as other diseases, including the deteriorating dizziness. These ailments and health problems seriously affects the concentration of my client in following the proceedings. In addition, his physical strength has deteriorated as well, and this is in line with the oral testimony of the witness of the expert, rather, that once his physical strength is diminished, then his cognitive function is consistently diminished, and this seriously affects the memory as well as the concentration of Mr. Nguyen Chie. Based on these grounds, even if my client is subject to trial and he is brought to the holding cell downstairs where equipment is installed for him to follow the proceeding, I find that it is meaningless, because he cannot concentrate on the proceeding and he does not have the ability to plead. And I only see that if you insist that he comes, then he only comes as per your orders. He cannot follow anything at all. And the experts also found that my client is suffering from many ailments. The expert should ask the chamber to order the examination, particularly if possible, and if it deems appropriate, my client should be placed under treatment until he is well enough to participate in the proceeding. At this juncture, I would like to earnestly request to the chamber that my client be referred to the hospital to get his diseases and ailment treated properly before he is ordered to participate in the proceedings. So long as my client is still suffering from the ailments, and so long as his health status is as worse as today, he cannot hear properly, he does not have the level of concentration good enough to follow the proceeding, I consider this as the violation of the right to fair trial of my client. Thank you. The President, how about the International Council? Do you have anything to add to your national colleague? The President, thank you. Then, if you do not have anything to add, I hand over the floor to the prosecutor to make the final closing statement in relation to the first topic of the hearing today. You may proceed.
Thank you very much, Mr. President. Let me start first by responding to the assertions made by Mr. Nunchea's counsel. These assertions are inconsistent with the testimony and report from the experts that we just heard, to put it simply. It is true that his client has a history of hypertension, one of the conditions he just said. However, as indicated in the report, his hypertension or blood pressure is under control. The recent blood pressure from his examination is within normal range. This is not a disease, the doctors have made clear, that in any way affects his ability or his fitness to participate. The respiratory condition relating to his bronchitis has been treated. He has recovered from that. And as for other things of which he complains, or which counsel has pointed out, such as the physical strength of his client, dizziness, matters such as this, Dr. Campbell's opinion was that this was the result of the accused's inactivity, something that he has the ability to change or to improve if he wishes to make the effort to have some form of rehab, some form of physical activity. In terms of the request that his client be treated until he is well enough to participate, treated for what would be my response? The doctors have made clear that the existing medication and treatment is sufficient for his problems and that his conditions are stable. The question, I think, for your honors is what has changed since your prior finding that Nunchea is fit to stand trial? In terms of his physical condition, Dr. Campbell has been clear that his condition is stable. His cardiovascular condition has remained stable since 2007. He is not suffering any significant ramifications from his 1995 stroke. There is simply no change in his physical condition that would warrant a change to the fitness decision previously made by this court. What has changed, I would note, of significance since your last decision is that Nunchea has now been subject to a full mental health evaluation by Dr. Fiza. You'll recall that during the prior period, following the advice of his client, Nunchea refused to meet with Dr. Fiza, and as a result, they were unable to conduct examinations and perform the tests that they have now been able to perform. So if there is anything that has changed, it is that the court now has a detailed report from the experts which confirms by any possible measure that with regard to his mental health, he is fit to participate. He has scored high on all the objective exams conducted, and subjectively, in terms of his interview with the doctors, it is clear that he meets the criteria. He was able to participate in interviews lasting several hours. He was able to respond to all questions, and more importantly, it is crystal clear from the report that he understands the nature of proceedings and is able to participate in his defense. So our submission would be that not only has nothing changed since your prior decision that would warrant finding him unfit, that the record supporting his fitness to participate is even stronger now. Thank you for the opportunity to make submissions, Your Honors.
President, thank you, Mr. Prosecutor. Now I hand over the floor to the lead co-lawyer for the civil parties to make your final statement. Counsel Hong Kim Soon. Good afternoon, Mr. President, and good afternoon, Your Honors. On behalf of the lawyers for the civil parties, given the fact that we have waited for a long time for justice to be done, and actually not only are the civil parties waiting for justice, but the defendant themselves wants the justice to be done expeditiously, but taking into consideration their health, it is of our collective concerns. According to the report submitted by the two experts, Professor John Campbell, document E256/4. This is a very well comprehensive report. The defense team's rejection to this report is groundless and unsubstantiated, because I don't see any reason why this report should be disregarded, because these two experts are internationally competent to carry out their function. They have accumulated experience in this, and they have been very objective in their assessment. And their report is quite comprehensive and detailed. Particularly, they administer certain tests, standardized tests, for example, the one administered in the Struga case. And Mr. Mr. Nguyen Chie is found to be fit to stand trial, and his health is not that serious that he cannot attend and follow the proceeding. And as for the request by the defense team that Mr. Nguyen Chie be placed under a treatment program for a certain period until his health condition return to normal, according to them, is utterly inappropriate. Mr. John Campbell is not only a competent individual, but he is also a geriatrician. And if, of course, we look at Nguyen Chie, he is now 86 years of age, and in terms of his cataract, if you find him difficult to read or to see something, that is not highly unusual for people at his age. If you look at the details of the two reports, particularly his conclusion, he does not recommend to the chambers that any situation is changed for Mr. Nguyen Chie to follow the proceeding. They only request that Mr. Nguyen Chie remains in the holding cell downstairs to follow the proceeding, because when he lies down, it is not an issue for him. So by staying there, probably he can follow the proceedings smoothly, and that will help expedite the proceedings. For these reasons, the civil party lawyers are of the opinion that the expert medical report by Professor John Campbell and Dr. Sina Fazol is comprehensive and appropriate. Therefore, the civil parties would like to request to the chamber to proceed along its schedule, so that the trial be progressing smoothly. And Mr. Nguyen Chie has made it very clear that he wants to follow the proceeding by himself, and he wants to participate in the proceeding, and at times he wanted to make oral statements as well. And if the defense lawyer says that Mr. Nguyen Chie's health is deteriorating, this is this has to be supported by experts' opinion, and according to these experts, who are well qualified and competent experts, affirms that he is fit enough to stand trial, and as the expert also take into consideration the fact of his health status at this age. And finally, according to the paragraph 44 of this report, that Nuon Chea wanted to tell the truth to the public, I, on behalf of the civil party, will be very pleased to hear his statement of the truth. And we actually support this assertion, and we want him to come forward to tell the truth. We have nothing to request but to ask the trial chamber to proceed expeditiously. Thank you. The President, you may proceed.
Oui, quelques mots pour d'abord indiquer que je...
I would like to say a few words just to say that I align myself with the submissions of the co-prosecutors and also to support the words spoken by my colleague of the civil parties. In spite of the attempt made by the counsel for Nuon Chea say that he shouldn't be declared fit to stand trial, the arguments are very clear. The experts are agreed that he is fit to stand trial, and they have provided arguments. I think the criteria for fitness to stand trial are clear to everyone. Regarding the physical health status of Mr. Nuon Chea, it is true that he is elderly. The experts have clearly shown that the physical status of Nuon Chea is stable, and there is no reason why he should not participate in his trial. And he himself would like to stand trial, as my learned colleague has just reminded us. However, regarding arrangements that can be made by the chamber, the civil parties would like this trial to move forward expeditiously, and that it should not be stalled by various problems. If the chamber would like to make any arrangements in that regard to ensure that the proceedings move forward uninterrupted and without any incidents, we deem it necessary to have Nuon Chea brought to the holding cell. Such a step is important not only for the civil parties but also for the public. We think that he should be brought to the holding cell and not kept in the detention center. Lastly, would like to make a suggestion to the chamber. Given the importance, again, for the civil parties, and in view of the fact that Mr. Nuon Chea himself would like to participate in these proceedings, we think that it is possible for us to envisage a situation in which Mr. Nuon Chea could be brought to the courtroom for everyone to see him, both the civil parties and the public, in order that they should be fully aware of the fact that Mr. Nuon Chea is present, that he wants to listen to the proceedings, and that he wishes to be present. I don't think that would be something very difficult for us to arrange. And I think that allowing the civil parties and the public to see him at the beginning of the proceedings would be a very good thing. I thank you.
The President, thank you. Now, I hand over the floor to the defense team for Mr. Nuon Chea to make the final reply if you wish to. You may proceed.
So
Counsel Sonarun. May it please the court, I would like to reply briefly to the civil party lawyers. As far as Mr. Nguyen Chia is concerned, and in my capacity as his defense lawyer, I have consulted with him and I have worked with him very closely. I am not a treating doctor, of course, but I have visited him on a daily basis. Now, I understand for the fact that one ailment that he is suffering from is the back pain, and the expert did not elaborate on this point. He cannot even sit upright. When he gets up for just 5 minutes, he collapses. That is the serious health condition he is suffering. And even if he is lying down, when he listens to people talking at a lengthy period, then he becomes diseased immediately. That's why I was requesting to the experts that they recommend the treatment program for him, and the expert failed to make any recommendation. I am suggesting that we need to find another expert in order to institute any treatment program for him. I know that everyone is waiting for justice. Everyone wants to see the conclusion of this trial, but the conclusion has to be fair. And we also want it to be expeditious as well. It is not at our advantage to prolong the proceeding. It is my conclusion that if Mr. Nguyen Chia health status is improved, then I believe that he will be responsive to the trial. Whenever you ask him a question, he will be responsive to your question. As the civil party made it clear earlier on that they want to hear the statement from Mr. Nguyen Chia. They wanted to hear the truth. So I also want to hear the truth. I also want my client to be able to speak in the court. So I would like to suggest to the court that so long as we have any treatment programs that improve his health and he can fully participate in the proceeding, in other words, if his health condition improves, even if he can sit for, say, half an hour, it is also even better. But today, his condition does not allow. I thank you very much, Mr. President. The President, thank you. The next session we will deal with the second topic of the hearing concerning the consequence of the decision concerning the severance of case 002. And the chamber will render the decision concerning the recent decision on severance. But now the chamber wishes to adjourn, and we will resume at 3. The chamber is now adjourned. 20 to 3, rather.